direct. And three, there will be some assignments. So just to ensure that we all are taking this 7 days program with all seriousness, though assignments would not be very tiresome, that much I can assure you. With this, now I must start with the objective of this program. Objective is to provide understanding of legal framework, general principles and procedures, as well as the stages of arbitration, domestic, international, and to make aware the participants with the best practices of arbitration, and to equip the participants with necessary knowledge in order to prepare them to act as arbitration counsel and as well as arbitrator. Now, we will start this course with the first thing first, and that is, what is arbitration? What is the definition of arbitration? If you try to find out definition of arbitration, you don't get definition of arbitration in your Arbitration and Conciliation Act. You don't find definition of arbitration in any other arbitration legislations anywhere in the world. Some authors have tried defining this expression arbitration, but everybody leaves it to the audience. Now, I have also tried to define this, and I'll request all of you to also define arbitration after today's talk. So, if I have to define arbitration, I would say that arbitration is a formal, private dispute resolution mechanism. It is a formal dispute. It's not informal, like negotiation and other informal ways. It is a formal decision. It's a formal private dispute resolution mechanism. Private dispute resolution mechanism as per the rules agreed by the parties or decided by the tribunal, which process produces the final and binding and enforceable decision by a private decision maker called the arbitrator. So this whole process is a formal process. It's not informal. This process is a private dispute resolution mechanism. So it is conducted in private. It is a confidential process. And this process is conducted as per the rules agreed by the parties or decided by the, failing which, decided by the arbitration tribunal. And this process produces award, and that award is final and binding. That means that the award will be final for the parties. It will be binding on the parties. And this award becomes enforceable in the court of law if the award debtor refuses to comply with the decision of the arbitrator. The award holder can approach the court, the local court, and get this award enforced as if it is a decree and judgment, or judgment and decree of the court. And the decision maker, the arbitrator, is a private judge. The private judge who is chosen by the parties, and if parties are not in a position to choose the arbitrator amicably, then one of the parties can approach the court, or if it is an institutional arbitration, one can approach to the institution concerned, and arbitrator is appointed. So this can be one definition of arbitration. You can try to define arbitration after today's talk, and I'll request all of you to try defining arbitration after every 3 months, so you can see the progress you have achieved in learning of this subject of arbitration. Now, before we go into other aspects, let me also talk about the career in arbitration. What are the career options? if you pursue arbitration. Why should you pursue arbitration? What do you achieve? So if you pursue arbitration, you can become an arbitration lawyer, you can become an arbitrator, you can become a tribunal secretary. In fact, Hong Kong International Arbitration Center, HKAIC, conducts a course on tribunal secretary appointment, and lots of people, young lawyers and young law students are opting for that. You can also join arbitration institutions. You can do internships there. You can join as case counsel there. You can join international arbitration institutions, other organizations. So these are the career options broadly. Now let us come to another important aspect, and that is history of arbitration. History of arbitration is long. It goes back to Roman times. In India, even your Upanishad talks about various forms of arbitration. In fact, in the year 2000, I remember I was doing one arbitration before one retired Chief Justice of India, Justice Rannath Mishra. He told me that in the Allahabad High Court library, there is one original arbitration agreement lying in the library, which was written on Bhojpatra by Goswami Tulsidas. Now, arbitration and this form is everywhere. No, I can't talk to anybody now. Now, issue is that for arbitration, two disputing parties, historically, how it has happened is that whenever two parties will have any dispute, they'll go to a third person. And traditionally, it used to be the wise men in the villages. And those wise and learned men used to decide their disputes. And whatever was used to be the decision, the disputing parties used to agree with that. And in some cases, if parties were not agreeing with the decision, in fact, the wise men or that society used to sanction the party who used to disobey the decisions. Now, this is the how it used to happen, and it continues to happen in certain part of world, and still in India, in villages, that is still prevalent. Now, what happened thereafter is, a state, the governments, the national governments monopolized this whole dispute settlement aspect. So you had courts, you had a hierarchy of courts, and the moment you had courts, so this hierarchy of courts and the state thought that dispute resolution should remain within the domain of the national courts, state courts. And initially, there was, I would say, distaste amongst the judges, amongst the courts, against the arbitration as a process. But later on, arbitration as a dispute resolution mechanism was accepted by the courts, accepted by the legislatures, accepted through the legislations, arbitration laws all across the globe. And today's situation is that courts in every jurisdiction lean in favor of enforcing, lean in favor of upholding the party's decision to go for this private dispute resolution mechanism. When parties used to go to wise men, learned men in villages, obviously those wise men would not know. And even today, when people go to the panchayats in villages, the panchayats would not know the substantive law of contract, sale of goods act. So what has happened is, even in your Arbitration and Conciliation Act, our Arbitration and Conciliation Act, we still have a window to have an arbitration where decision given by a particular arbitrator who doesn't know law and who does not apply law in a particular dispute still can be enforceable. And for this, if you look at section 28 of Arbitration and Conciliation Act, it has got provision for, it says that arbitrator can act as amiable compositor, or he can act as ex equo et bono. Now, what does it mean when it says the initial part of section 28 says that arbitrators will be guided by, bound by the substantive law of the country? But in later part of this section 28, it says arbitrator can act as amiable compositor. That means that arbitrator, but only a rider is that if parties have expressly agreed that arbitrator will decide as amiable compositor, only then arbitrator can act accordingly. Now, what is this? What is this phrase? This phrase means that arbitrator, if parties have so agreed, can decide the dispute based on his own conscience, on the basis of equity, what he thinks is equity. So then in that case, he would not be bound by your substantive law, law of contract, law of sale of goods act, or transfer of property, whatever may be the law applicable in your particular dispute. So you still have that window open. There are certain jurisdictions where it says it is other way around. If you have not agreed otherwise, then what happens? So it says that if you have not said that arbitrator cannot decide as amiable compositor, then he can. But that is not the case in India. Now, invariably question is asked, what all should we read in order to understand arbitration? What are the material which we should read? Now, for this, I would say that first thing you should do is, you should read your Arbitration and Conciliation Act. That is the first thing you should do. Second thing you should do is that you should read Law Commission's report. Law Commission's report, at least two reports I'll encourage you to read. One Law Commission's report is of the Justice A.P. Shah was chairman of that Law Commission, on the basis of which 2015 amendments, substantive amendments were brought in Arbitration and Conciliation Act. And second Law Commission's report would be, it's not Law Commission report, it is basically called High Level Committee report. This committee was appointed by Government of India under the chairmanship of Justice B.N. Sri Krishna, retired Supreme Court judge. In fact, I was also invited to give my presentation before the committee, and you will find my name mentioned in the report. And that report, again, is very exhaustive report. It talks about various important aspects of present arbitration regime in India, about international arbitration, about domestic arbitration, about accreditation of arbitrators, about Indian situation and status with regard to bilateral investment treaties and all. So that would be another interesting read for all of you. Now, when I said that you should read Arbitration and Conciliation Act, the preamble of your act says that this Arbitration and Conciliation Act is based on UNCITRAL model law. Now, UNCITRAL model law is a model law of 1985 of United Nations, and United Nations basically encouraged all the trading nations, all countries, to have their local arbitration legislations on the basis of this model law, so that there is uniformity in arbitration regime and arbitration culture all across the globe. Because now we are in a world where we are up, and particularly after this globalization, and you have transactions, you have lots of international transactions happening all across the globe. So it is important that all nations have similar arbitration law. And today India is having its Arbitration and Conciliation Act 96, which is based on UNCITRAL model law. And same is the case with other trading nations. So if you read the legislative history of UNCITRAL model law, that will really give you a very good insight about how this particular model law was drafted, what all discussions went behind. It's, you can have an analogy. If today you have any issue with a particular provision of article of constitution, and there are several interpretations which are being given by parties, or so now how do you resolve that? So you refer to the constitutional debate, and if you refer to constitutional debate, you get to know how a particular article was written, what was the logic behind why it was written the way it is. So same is would be the situation if you want to understand a particular section of your Arbitration and Conciliation Act, which is based on the particular article of UNCITRAL model law. You should look at the Travox Preparatories, that is the legislative history. And this Travox is freely available on the website of UNCITRAL, so you can visit that. Another thing which is with regard to UNCITRAL is that it has got digest of cases, digest of decisions on arbitration, those decisions of the courts on the various provisions in their own jurisdictions. So we will call them model law countries. So countries where model law is being followed, and decision given on a particular provision, and that particular provision is you have some issue with similar provision in your jurisdiction, you can rely upon that, and you can see how a particular court has understood and interpreted that. That is another interesting thing. Apart from this, one would like to also know what books are relevant books for the purposes of arbitration. I would say that I'll recommend 3 books. You can buy either of the 3. One book is I would recommend for paperback edition, that is by Gary B. Ball. And second is by Redfern and Hunter. That is second, Redfern and Hunter. And third is by Margaret L. Moses. This third book, Margaret L. Moses, is very popularly referred in American law schools. And the book by Redfern Hunter is referred very often in law schools in UK and this part of world. So you can refer to either of the 3. They give you very good insight of the subject. Apart from this, what you should also look at, if you see your part 2, when modern law was brought in, modern law gave a message to the world that domestic arbitration is different from international arbitration. Therefore, we should have 2 legislation. One legislation for international arbitration, another legislation for domestic arbitration. Though in India we have one legislation. However, what we have done is we have 2 parts. Our act is in 2 parts. Part 1 deals with domestic arbitration. Part 2 deals with foreign arbitration. Now, so for this international arbitration, for the purposes of international arbitration, there are a couple of material you can refer to. One is New York Convention. That convention is in fact Schedule 1 of your Arbitration and Conciliation Act. You should have a look at it. And apart from this, you should look at the rules of arbitration institutions. We will deal with these arbitration institutions in a while. Uh, so who are these arbitration institutions? Like ICC Paris, International Chamber of Commerce Paris, which is the most popular arbitration institution in the world. You have LCIA, London Court of International Arbitration. You have SIAC, Singapore International Arbitration Center. You have HKIAC, Hong Kong International Arbitration Center. You have AIAC, Asian Institute of Arbitration Center, Kuala Lumpur. So you have various arbitration institutions involved. Read the rules of ICC, for instance. And if you read rule of one arbitration institution, it will help you in understanding rules of other arbitration institutions as well, because broadly they would be same. So that really helps you in understanding how international institutional arbitration is conducted. Another thing we can look at is the soft laws. There are certain very popular soft laws. So what is soft law? Soft law is not a legislation in any country, but these are the publications referred to as guidelines or protocols, which embodies the international best practices, which are invariably followed by arbitrators all across the globe. So these publications are issued by some very relevant institutions like IBA, International Bar Association. IBA has got some soft rule, and I'll name three at least, which would be very relevant for all of you. First is IBA guidelines on taking of evidence. This particular guideline is used in almost 60% international arbitrations today. This is the study of Queen and Mary College some years back. This basically talks about various evidentiary rule, how evidence is to be laid in an arbitration, about the witness statement, evidence by affidavit, about the cross-examination, role of experts in arbitration. And so you get to see all of this in this IBA guidelines on taking of evidence, which you do not find written in your arbitration act or anywhere else. Another thing is IBA code of ethics for arbitrators. So IBA also has a guideline or protocol which talks about the ethics of the arbitrators, how arbitrators should conduct themselves, which is very important. In fact, AAA, American Arbitration Association, has also got a code of ethics for arbitrators. Another thing which is again can be a very interesting note for all of you, which is UNCITRAL rules on organizing arbitration. So you'll get to learn how typically arbitration is conducted and organized. Another interesting read can be ICC case management techniques. So this is ICC publication. In fact, you should also read interesting blogs. In fact, there is a database of all relevant websites all across the globe. I'll ask the organizers to circulate this to all the participants, so you can have those database for your reading. Now let us come to another aspect of arbitration. Types of arbitration. You have something called ad hoc arbitration. You have something called institutional arbitration. What is ad hoc arbitration? Arbitration which does not happen under the rules of any institution. So you enter into an arbitration agreement, you agree with the other side that if we will have dispute, we will arbitrate. You do not say we will arbitrate and we will have arbitration under the rules of any particular institution. So you don't want your arbitration to be administered by any particular arbitration institution. You can or you may not. It's your choice. It's all about your choice and autonomy. Now, institutional arbitration is an arbitration where parties, as I said, parties agree to have their arbitration administered under the rules of a particular institution. Even in India, we have some institution like ICA, Indian Council of Arbitration. We have ICADR. We have MCIA, Mumbai Center of International Arbitration. So these in fact, Delhi High Court has got its own arbitration institution that is called DIAC, Delhi International Arbitration Center. Various other high courts have court annexed arbitration centers. So these are all institutions which helps you in administration of your arbitration. So these institutions will have their own rules, how the whole arbitration will be conducted. And so your arbitration will be governed by those rules. And wherever you have gap, wherever a particular issue or area is not covered by those rules, then arbitrator will decide about that particular aspect. And if there will be conflict between any institutional rule and the arbitration act or legislation of that particular jurisdiction, in that case, any conflict with mandatory provision of the arbitration legislation. I must repeat, if there is conflict between a particular provision rule of that particular institution and any mandatory provision of any local legislation like Arbitration Conciliation Act in India or similar legislations in other part of world, in that case, mandatory provision of the arbitration legislation will prevail. So that is one thing one should keep in mind. So this is typically the difference between ad hoc and institutional arbitration. In fact, when it comes to international arbitration, where one of the parties will be from foreign jurisdiction, invariably, not in all, but invariably, these arbitrations are governed under the rules of these people. The parties agree to have institutional arbitration in order to have their arbitration processes streamlined and in order to ensure that the appointment of arbitrators procedure is smooth. So that these are, in fact, there are certain countries involved, particularly China. In China, you cannot have ad hoc arbitration. In China, any decision rendered by an ad hoc tribunal is not enforceable. That is against the law. So in China, you can only have institutional arbitration. In China alone, there are hundreds of arbitration institutions. So there are some other countries like this, 2-3 more. Now let us talk about domestic and international arbitration. What is domestic arbitration? Domestic arbitration is the form of arbitration where both the parties are from same country. Like for the purposes of India, if both parties are Indian parties and they are wanting to have their arbitration in India, this is called domestic arbitration. Now, Vidur says that whether court annexed arbitration center is different from institutional arbitration. No, it is not. Just because a particular arbitration institution is annexed with a court doesn't mean that it loses its significance as an arbitration institution. Now, the domestic arbitration we talked about. International arbitration is an arbitration form of arbitration where one of the parties would be from foreign country, from other jurisdiction. This is also defined in your Arbitration and Conciliation Act. It says that if one of the parties is from other country, so it is international arbitration. So this is basically And what happens in international arbitration typically is parties, let us take an example uh, that one party is from India, another party is from Australia. Now, they can agree to have their arbitration in Singapore. Now, and for that, they may agree that we will have arbitration in Singapore under the rules of Singapore International Arbitration Center. So that is called SIAC in short. So Indian party and Australian party can agree to have their arbitration in some third country. But that doesn't mean that both parties cannot agree to have arbitration in one of these two countries. So Australian party could have agreed that we will have arbitration in India. In that case, arbitration will happen in India, but it will remain international arbitration. Similarly, Indian party could have agreed to have arbitration in Australia, but that will remain again international arbitration in Australia. Now, so far as international arbitration is concerned, the three aspects which are very important for all of us to understand. One, that there would be three aspects, three categories of law, three types of laws which will have its application when it comes to international arbitration. And we have to go a bit slow with this because sometimes it becomes complex. It will become complex for some of you. First law which governs international arbitration is called the governing law or substantive law. So if this Indian and Australian, these two parties had entered into a contract, let us say it was a joint venture contract, and invariably what we find is in all such contracts there is a governing law clause which would say that in relation to this particular contract, law of India will apply, or law of Australia will apply, or law of some third country will apply. What does it mean? It means whenever there will be dispute between the parties, on the merit of disputes with regard to the rights and obligations of the parties, law of that particular country will be applied. So law of that chosen country will be applied. So that is one law which governs the rights and obligations of the parties under the contract. That is one. Second is lex arbitrae. That is law of arbitration of the seat of arbitration. So if Indian and Australian parties had agreed to have their arbitration in Singapore, in that case, arbitration law would be of Singapore. If both these parties would have agreed to have arbitration in India, then in that event, arbitration law of India would have got applied. Now, so this is called lex arbitrae, arbitration law of the country where arbitration is seated. So that is second category of law. And what is this law? Basically, arbitration law takes care of the default situations. It basically provides you a legal framework for conduct of your arbitration. Now, third law, which becomes of an importance in some situations. In fact, presently I am doing one arbitration in Japan, and we have an issue about the validity of the arbitration agreement. One gentleman, Abhishek Tripathi, has asked a question: what is the difference between seat and venue? In fact, you can read a judgment of Supreme Court in Brahmani Pilot matter, In fact, I had argued this matter before Supreme Court, judgment subsequent to that as well. So you can refer to this. Seat is a legal concept. So if you say that the Indian and Australian party will have their arbitration in Singapore, then parties have agreed that law of arbitration law or arbitration act of Singapore will apply. Now, however, the arbitrator or the parties can, for convenience, decide to have some of the hearings in Kuala Lumpur or in Delhi or in Sydney. Just because you are having hearings in other city or some other place does not mean that seat had changed, because seat gives umbilical cord to the whole process. What is the relevance of seat? One relevance I'll immediately tell you is this: if arbitration has started and like you have certain situations, provisions here in your Arbitration and Conciliation Act, you want to summon some third party as a witness in your arbitration. Now, what do? Your arbitrator cannot summon third party to the arbitration. So, provision section 27 of Arbitration and Conciliation Act says you can go to court of law and court will help you in getting that particular person witness summoned. Similarly, now another important example is what happens if one of the award is given and one of the parties is not happy with the award. What will he do? He challenges the award. Now, where will you go to challenge the award? Award can be challenged only in the court of the seat of arbitration. So if parties had agreed that arbitration will happen in Singapore, these two parties, then you will have to challenge that award only in the court of Singapore, because that award becomes citizen, not in that technical sense. Just for analogy, I may tell you that you can remember this in better way, that award becomes citizen of the place where arbitration is seated. And where can you challenge the award? You can challenge the award where arbitration is seated. That is the thumb rule. Obviously, one may ask the question, where can we enforce the award? Where can we execute the award if the award debtor or judgment debtor is not complying with the award? You can execute the award anywhere in world, wherever you find assets are lying of that particular award debtor. Award debtor is one who against whom that award has been passed. So you can go to any court where that particular entity or person is having his asset. However, there is one limitation, and that limitation is you cannot go to every country to get that award enforced. And for that, one has to understand this New York Convention, which is the convention, and today 164 countries out of 197 countries in world are signatories to this convention. This United Nations Convention, which gave big boost to this whole concept of international arbitration. This is of 1958. So today, almost all nations are parties to this, this convention. And what is the result of this? Result of this is, if you have got award passed in a convention country, means if Singapore, in this particular instance, if Singapore is signatory to New York Convention, party to New York Convention, an award is given in Singapore, and tomorrow somebody wants to enforce this in India, you can enforce it because India is also signatory to New York Convention. You can enforce this in UK because UK is also party to this convention. Similarly, you can enforce the award in 164 countries, and therefore enforceability of award is very smooth. You can go to 164 countries and get your award enforced. So that is the broad thing about this. Now, let us talk about advantages and disadvantages of arbitration. Because what are the advantages of arbitration? First advantage of arbitration is that you can choose your own judge, which you cannot do if you do not have any arbitration agreement and you are going to court. If you go to court, what happens? You cannot choose the judge. You will have to present your case before the judge, who is doing matters on day-to-day basis for everybody. Secondly, when we say that you cannot choose the judge and you can choose the judge in arbitration, what does it mean? You can choose the judge of your own liking, of the expertise which you think would be appropriate for decision of your case. Let us assume that you have got construction arbitration, complex construction arbitration. You may want an arbitrator, decision maker, who understands construction law well, who can handle construction law matters, who understands construction arbitration appropriately. So you will choose such a person. Or if you have not chosen such a person, then in that case, court will assist you, or the institution will assist you in getting you an arbitrator who understands construction law, and that this is how it should be. In fact, I remember in 2014 I was doing one arbitration in London, and it was an issue with regard to a defective machine, and it was an ICC arbitration. Now ICC appointed one gentleman as chairman, who was mechanical engineer turned Queen's Counsel, because requirement of the case was that chairman or the tribunal had to decide whether the machine which was supplied to the Indian party was defective or not. So so you can choose a decision maker of your own choice. In fact, you can agree in arbitration whether I'll have one arbitrator, that is called sole arbitrator, or we need 3 arbitrators. I have a question for everybody. Just think over in second and then and give answer to yourself. Can you have 33 arbitrators in a particular arbitration case? Just think over in 1 second. See, your Arbitration and Conciliation Act says number of arbitrators should not be even. It doesn't bar the number of arbitrators. So you should not have even number. You should not have 2, 4, 6, 8 and so on, but you can surely have 33 arbitrators if that is the requirement of the case. In fact, I had once dealt with a situation where it was a partnership. It was a partnership firm, and dispute arose among the partner. So when they approached me, I saw this partnership deed. There were 11 partners. An arbitration clause said that all the 11 partners will appoint arbitrator. So obviously, in that particular case, you could have 11 arbitrators. But obviously, for all good regions, people don't go beyond 3 generally, until unless you have multi-party arbitration, where you have more than 2 parties, and or the other parties also want to have their arbitrator. So, this is the benefit of arbitration. You can have your own judge. This process is not as formal as court proceedings. It is like a boardroom setup where you get sufficient time to present your case. Everybody sits. Lawyers are not supposed to be arguing, standing like the way they do in courts. So it is an informal setup. You get sufficient time to present your case. Generally, arbitrators would not say you have, like the way it happens in courts, you have sometimes few seconds or few minutes are allotted to you, and courts say, sorry, we will not hear you more. But that doesn't happen in arbitration. You are given enough time, to sufficient time to present your case. These are the benefit. Another benefit is it is confidential. And there have been various reports which says that large corporations agreed to have arbitration as a dispute resolution mechanism, primarily for the reason that it is confidential, because parties do not want their dispute to go public, because there would be a lot of confidentiality attached to the dispute. Your own business issues, commercial issues, confidential issues. So this is another very good example. Uh, Another very good reason is finality, which is attached to this arbitration process, the arbitration award. What is this finality? If you have gone to court of law, what happens is, if the court of first instance, the court where you approach for the first time, gives a decision which is called judgment and decree, and if one party is not satisfied with that particular judgment or decree, that party can go in for first appeal. Now it may take years together. If one is still not satisfied from the decree of the first appellate court, one can go to second appellate court, and so on. So then you go to Supreme Court. Now, and another important thing is, when you challenge the decree before the appellate courts, first appellate court, particularly in India, will revisit entire dispute. First appellate court is empowered to go into all the facts, all the laws. First appellate court would assume that this case is brought before me afresh, and I will decide the way I want to decide it, notwithstanding the decision of the court of first instance. However, this does not happen in arbitration. Once award is pronounced, that award is final, so far as finding of facts are concerned, finding on laws is concerned, it is final. Now, one may ask that we still have provision for challenge to the award in our Arbitration and Conciliation Act, that is section 34, and there are similar provisions in other jurisdictions. What is this meant for? This particular provision for challenge to award is meant only for one thing, that particular court where you challenge the award will go into only 2 aspects, broad aspects, very broadly. One is, not very broadly, there 2 aspects. One is that there should not have had any violation of principles of natural justice, or in other words, violation of due process. So that is one thing court will look at. Second thing is that award should not be against public policy. So court will examine whether award is against the public policy. Suppose two parties agreed that party A will pay 100 rupees to party B and party B will break the leg of somebody else. Now that person did not do that and he did not refund the money, and both went for arbitration, and an arbitrator says the person B is supposed to return that money, and you go to court and you say that I had agreed with him that in consideration of rupees 100 he will break the leg of somebody else. He did not do that. He is not giving my money back. Court will say go to hell. The whole agreement itself was against public policy. Law in India does not permit any such contract, and courts say that these are all against public policy. So these are only two categories. Suppose award is obtained by fraud. So only these very difficult situations. So therefore threshold of challenge under section 34 is very high. These are the two broad categories under which you can challenge the award. You cannot say that arbitrator decided the case, arbitrator has not appreciated the evidence properly, arbitrator has not appreciated the facts properly, arbitrators has not applied the law properly. These are not the grounds on which you can challenge the award. So see, one award given, so therefore award given in any particular proceeding is having more force than any degree of court in terms of its finality. So that is another very good benefit. You are not supposed to spend your years and years in appellate courts. That's another good and another very important aspect is when you go to court, what happens? All proceedings, all civil disputes, all civil proceedings are conducted as per the requirements and as per the provisions of Civil Procedure Code. So you have one CPC meant for all civil disputes all across the country. So thousands and thousands of people will go to court with their own disputes, and same CPC apply. Now, question therefore is, what happens in arbitration? In arbitration, you, the parties or the tribunal, will tailor make the provisions as per the requirement and nature of the dispute. Tirthankar Das has written that what is the public policy of India? See, this is a very vast subject. We may need a couple of days to really discuss this. However, I'll advise you to read Sangyong judgment of Justice Nariman of Supreme Court. That judgment is the best ever judgment written on public policy and the scope of challenges under the new regime. Prior to that, the best judgment you had was Renu Sagar. So you read Renu Sagar judgment of Supreme Court and this Sangyong judgment. These two judgments will help you in understanding what is the public policy, what are the grounds on which you can challenge the award, what amounts to fraud, what is patent illegality. So all of this. So that is one thing. Now, another advantage is proper representation in arbitration. It is not necessary that in arbitration only lawyers can represent the parties. In courts, under Advocates Act, requirement is only lawyers who are qualified degree holders of law degrees and is enrolled with Bar Council, only those people can appear and represent you. In fact, presently I am doing one arbitration, very big construction arbitration. Rather, there are two similar arbitration, and in which I am the presiding arbitrator. In fact, the claimant is represented by a gentleman who is not a lawyer by profession, who is a technical person, and who is doing a good job. So you don't need to really have this requirement of lawyer representing you when it comes to arbitration. So parties can very well argue themselves. And you get sufficient opportunity to present your case. This is the requirement of your section 18 of Arbitration and Conciliation Act as well, that parties should be given sufficient opportunity to present their case. Now, these were like earlier, people used to say that another advantage was of cost. Now, I would not say that arbitration is always cost effective proceeding. Sometimes it may not be, sometimes it may be. Another thing was that earlier in India, people used to say that courts are taking years and years in deciding the cases. And people thought that arbitration would be a speedier process, and people started going to arbitration. But we had gone in an era where even arbitration proceedings used to take years together. In fact, once I remember one file came to me for my opinion. An opinion they sought on one point, how many more years this arbitration will take, because that arbitration was going on for 26 years, which was really ridiculous to say the least. Now, however, now you have amendment in 2015 in Arbitration and Conciliation Act, which says arbitration has to get over in 12 months. Thereafter, parties with consent can agree to have extension of 6 months. And thereafter, court can extend the timeline for pronouncement of award, or if parties do not agree, then one of the parties can go to court and court will appoint the extend the time. So now what happens? There is a check here. Arbitrators cannot slip over the matter, cannot delay unreasonably, because now you have provision, section 29A, which also says that if court thinks and court feels that arbitration, this particular arbitration is being delayed unreasonably, then court can remove the arbitrators. Or if court finds that one of the parties is unreasonably delaying the matter, dispute, arbitration, then court can sanction, impose cost. So now we are in an era where delay, which used to happen in arbitration, has gone. So I would definitely say now that arbitration is much more time effective in India. And we cannot say same thing about every jurisdiction. It depends on the jurisdiction you are talking about. In some jurisdictions, court proceedings are faster than arbitrations. But if you talk about India, surely arbitration gets over much earlier. So this is another advantage you have. Now, what are the disadvantages? One is that you must have arbitration can happen only amongst the parties. Unlike in court, where you can go and sue all the concerned people against whom you have got cause of action. In arbitration, you can only go and sue the party with whom you have got arbitration agreement. So existence of arbitration agreement is necessary, and that is one disadvantage. However, there are certain developments globally. Now, there are certain circumstances where even proceeding can be brought against non-party. In fact, I just referred to one Japanese arbitration which is seated in Tokyo. I'm pursuing this under the rules of JCAA. Now, I have implemented one very big corporation as respondent in that arbitration, though there is no arbitration agreement with that particular party. Now, one may ask the question, then how can you implement that particular party? For that, there are certain exceptions which have been carved out. And what are those exceptions? I'll give you some example. Like you are in a situation where you have assignment of the right. So even though you may not have any agreement with the assignee, but you can always bring in that particular arbitration against that particular person. So it is a case of assignee. Subrogation. Even in the case of subrogation, it is permissible. However, there are certain requirements that you must initiate the proceeding in the name of the party who subrogated the rights, uh, there is a doctrine of group companies. So if you have arbitration agreement with one company and you want to sue other companies of that particular group, you can go against other also. Suppose you have related contracts and all the contracts doesn't have arbitration agreement, but you have your cause of action against all the group companies or some of the group companies, you can still go against them. Similarly, you have a alter ego principle, like you can go against the agent or you can go against the principal, vice versa. There is a principle of equitable estoppel. If a particular party has taken benefit of the arbitration agreement, he cannot tomorrow turn on to say that no, I am not signatory to that arbitration. So there is scope for that as well. In fact, the best judgment you can refer to on this is one judgment is chloro control of Supreme Court, chloro control. Another judgment thereafter came up, Charan judgment of Honorable, written by uh, 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 Justice Chandrachud. First judgment was written by Justice Swatantra Kumar. So beautiful judgments, and these are the principles which are now accepted all across the globe. In fact, the judgments refer to various foreign judgments and legislations. So that is a very interesting aspect about this. Now we have to go to other important aspect of this talk, which is about arbitration agreement. And in this, we are going to talk about what is the purpose of arbitration agreement, why do you need arbitration agreement, how to write arbitration agreement, how not to write arbitration agreement, what are pathological clauses which are which are not enforceable in court of law, what do we mean by defined legal relationship. So again, how to write. So there we will discuss about seat, about the language, about the binding nature of this, the governing law of this. In fact, uh, invariably we come across, I came across a situation where the arbitration clause said that in the event of dispute between the parties, party A from country A, B will invoke arbitration in India under Indian Arbitration Center, India International Arbitration Center. And if this Indian company will invoke arbitration, he will go to that particular country and invoke arbitration under a particular institution. When dispute arose, and that particularly foreign company wanted to invoke arbitration in India, there was no such arbitration center in India, India International Arbitration Center. There has never been any international India International Arbitration Center. So what do you do then? So matter went to Supreme Court, and matter traveled up to Supreme Court, and in Supreme Court, the Honorable Supreme Court wanted to appoint one retired judge of Indian court. So there I had argued that though we do not have anything called India International Arbitration Center, but one thing is clear, that parties wanted to have institutional arbitration. So let us have institutional arbitration. And the Supreme Court referred the parties to have their arbitration under the rules of SIAC, Singapore International Arbitration Center. And in SIAC, again, I represented one of the parties and we succeeded there. Now, with regard to the same dispute, after 6 years, disputes have again arisen. Now, Indian party has gone to country B. There, that particular arbitration exists, and that arbitration has started in that foreign country, and I am representing that Indian country. So, two parties, same contract. When foreign party invoked arbitration. Arbitration happened in Singapore. Now, when Indian company invoked arbitration, arbitration happened in some other country. Why? Because parties, while writing the arbitration agreement, did not write it properly. In fact, I did one arbitration, ICC arbitration in London, where the arbitration clause written was very short. It only said that arbitration under ICC rules. It did not say anything else. It did not say what will be the seat of arbitration, what would be the governing laws of arbitration. No indication, no express consent, no implied consent, nothing. So we approached ICC, and the other side raised the threshold challenge. We succeeded there, and thereafter ICC decided to hold hearing in London. We went to London, and almost 8 months were taken in deciding the jurisdiction of the tribunal, seat of the arbitration, and it was all waste of money, waste of time for everybody. They in fact challenged the jurisdiction of the tribunal itself. Though I succeeded there, I cross-examined witnesses and all, we succeeded there. Now, so we will go into all the details of this particular aspect. Oh, Sumit Malhotra has asked the question, is there any provision in Arbitration and Conciliation Act akin to Section 151 CPC? In Civil Procedure Code of India, you have Section 151, which gives power to the residual power to the court, even if you do not have any particular provision to take care of a particular aspect. You invoke this inherent jurisdiction of the court, and court, by virtue of being court, can pass appropriate order. But in arbitration, we do not have any such provision, though there are certain default powers, quote unquote default powers, which arbitrators have. But courts, it is not a court of equity. It cannot go beyond the provisions of the legislation and the procedures agreed between the parties. I think now time is up. 7 o'clock. Time is up. I should not burden you on the very first day of this talk. Tomorrow we are going to have interesting aspects which we are going to cover, like how hearing happens, how international arbitration hearings take place, what is the layout, how do you address the tribunal, how do you address the other side, where do you sit, which side of the tribunal which you sit, which tribunal member sits on which side, what is chess clock method, what is Cladderbank method. So we will be talking about various interesting aspects, and we will also be talking about how a typical arbitration happens. So we will discuss from beginning till end as a process, what are the processes involved typically in a particular arbitration, so that it gives you complete idea about how arbitration works. And then we will go into various other aspects. What are the roles and duties of an arbitrator, how arbitrators should conduct themselves, how awards are to be written, how awards are to be passed. So we have various other important aspects which we are going to talk about. We are going to talk about international best practices, and we will talk about how you should equip yourself as the best as the arbitration counsel, as the arbitrator, what attributes you must possess. So we are going to have all of this in tomorrow and the talks which we have on other days, following days. Thank you very much. If we have any question, I saw a couple of questions which I answered, but if we have still a few more minutes, if we can, and I'll ask the organizers for that.
So most of the questions are related to the discussion which will be held further. The questions are related to
Oh,
public policy and awards. So I think we can take up.
yeah.
I'll
They
note down.
defer these questions for, yeah.
So we'll take them, guys. We participants, we will take these questions which are not relevant for today's discussion. We discussed the very basics of arbitration, so we will take them along with the discussion. So thank you very much for your participation. Please be present tomorrow at the same time, and on the we will be going live on Facebook with the same link, and we won't be able to accept more than 100 participants in the Zoom. So please try to be present at the Facebook platform. Thank you so much. Thank you, sir.
Thank you. Thank you, everybody. Thank you.